through J, she does not have specifically admitted, but she does show that Your Honor allowed us to publish them, so I would just ask that they be formally admitted. This was where we had 99A through J and 99A2 through J2. It would have been during Lieutenant Wells' testimony on Friday.
I've got 99 got admitted into evidence over defendant's objection, 99A2 through 99J2 admitted into evidence without objection.
So it may have just been that I wasn't clear. As I said, in that case, this was, I believe, the HGADE email. And so 99 was the portion of the report that showed the HGADE email. 99A through J would have been the images. Let me just double check that.
Yeah, I don't have 99A through J. I've got 99A2 through 99J2.
Right, and so I probably just was not clear when I spoke. I handed Lieutenant Wells both 99A through J and 99A2 through 99J2, and we went through them at the same time. So 99A was the IMGDB image from the HGADE email, and then 99A2 was showing that that image had been cached on the defendant's phone prior to the email being sent.
So you're seeking to admit now 99A
through J.
Through J.
Yes, Your Honor. And I believe we did go through them at the bench.
Mm-hmm.
And all of this is part of State's Exhibit
99. Yes, so in 99, Your Honor, you can see smaller versions of the images. So then Lieutenant Wells testified that he went to that image and then was able to show that image on the defendant's phone.
All right, what's the defense position?
Your Honor, we objected to them as they were coming in. Whatever the record shows, Your Honor, the record shows they're not in. They're not in.
Okay. All right, I'm going to admit State's Exhibits 99A through 99J. Since State's Exhibits 99 is already admitted into evidence, and these are just a portion of that.
Yes.
Good. Okay.
And then, Your Honor, there's some question as to 62 and 63. The state shows that they were admitted during Detective Edwards' testimony. Those are discs of the surveillance from Lowe's. So it would have been the point of sale surveillance and the parking lot video.
Jury, whose testimony?
Detective Drew Edwards. I think he would have been Wednesday.
He was.
I believe he was Wednesday.
You're talking about Defendant's Exhibits what?
State's Exhibits 62 and 63.
Yeah, they were never put in. What's the defense position?
It's fine, Your Honor. They're not in this. I don't believe we
That
covered
was
it.
marked for identification, never admitted in evidence. What's the defense position?
Whatever the record shows, you know.
All right. State's Exhibits 62 and 63, they want to put in. I'm not going to put in.
That's fine, Your Honor.
All right, anything else on this study?
Nothing from the state, Your Honor.
Anything from the defense before we bring the jury in?
Nothing from the defense, Your Honor.
All right, let's bring the jury in. gentlemen, welcome back. Hope everyone had a good weekend. Hope everyone had a good Father's Day. We're ready to resume with the trial of this case. Please make sure you have your own notepads and no one else's notepads. State and call your next witness.
Your Honor, at this time the state rests.
All right, ladies and gentlemen, the state has rested their case, and now is the time of the trial where I have to take up some matters of law with the defendant, with the parties, the state and the defense. As I told you earlier, when we discuss the law, it often requires us to reference factual issues, and we don't want you to be influenced by anything that I say or the attorneys say. So I'm going to excuse you back to the jury room for just a few minutes, and we'll bring you back out in just a second.
We move for a directed verdict on the conspiracy charge. Testimony in the case from all witnesses is that there was no agreement between Ms. Jackson and Mr. Dontell. Of course, that's required for a conspiracy charge. He testified very forcefully. He knew nothing about it, had nothing to do with it, hadn't agreed to anything. So, under the facts and the law, that charge should be dismissed.
All right, the state's position.
Your Honor, we would ask that you deny the defense motion. In order for a directed verdict to be granted, there must be a failure of competent evidence, and in this case, we believe that there is ample evidence that the defendant and Mr. Dontell acted together. We believe that the conspiracy continued through the disposal of Mr. Rice's body. Certainly, there is evidence that they went to the preserve on the 29th, the 30th, and the day that Mr. Rice was murdered to engage in target practice. There was a text message indicating the defendant, I believe, said, "I'm all for popping a tire now." And Mr. Dontell said, "I agree." I believe that's a question for the jury.
So you're saying Mr. Dontell lied on the stand when he said he didn't know anything about it, she jumped out and started shooting?
No, Your Honor. I believe that the way his testimony came across was that he thought she was kidding, and he actually testified at one point. She said, "I hate my kids, I hate my mother, I hate this person, I hate that person." But the conspiracy certainly lasts through putting Mr. Rice's body in the back of the van, storing him at the Myrtle Beach Funeral Home, and disposing of his body.
No, conspiracy is a pre-arranged plan prior to the act. Disposing of the body is the accessory after the fact. Conspiracy, you have to have a pre-arranged plan between two or more people to commit the crime, and that they actually carry out that crime pursuant to the pre-arranged plan. What evidence do you have that there is a pre-arranged plan between this defendant and anybody else to commit murder?
Your Honor, I would just point to the evidence that I've already highlighted, but I will leave it in the court's discretion, certainly.
All right, I'm going to grant the motion as to the conspiracy charge. I don't see where the state has presented any evidence of a pre-arranged plan between this defendant and any other person to commit the crime.
Your Honor, on the remaining charge of murder, as I understand it, that would be the only charge
That's correct.
remains.
That's correct.
We would like to have that dismissed also based on this theory that the reliability of Mr. Dontell is so flawed. Even the prosecutors brought out that he lied many times. He returned, he said he was afraid, he admits returning to his relationship with Ms. Jackson. So our position is no reasonable jury could find there was murder here because they would have to believe Dontell. And his testimony is so flawed that that wouldn't be a just verdict.
All right, I'm going to deny the motion. I think the fact that he has testified at least creates a jury question as to whether or not he's believable or not. So I'm going to deny that motion. All right, any other motions? want to go ahead and let me question your client on her right to testify?
Yes, sir, Your Honor.
And if I can get you to stand and raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Your name is Meagan Marie Jackson.
Yes.
All right, Ms. Jackson, at this time, I'm going to explain to you certain rights that you have. If you do not understand anything I say, please let me know. And if you want me to explain anything in more detail, please let me know. You understand that?
Yes.
All right. We've now reached the stage of the trial where you may present your defense. You have the right to claim the protections given to you by the Fifth Amendment to the Constitution of the United States. This amendment states in part that no person shall be compelled in any criminal case to be a witness against himself. This means that you cannot be required to testify in this case. You have the right to testify on your behalf. However, no one can make you testify. This is a personal right, and no one can waive this right except for you. If you decide to testify, you will be subject to the same rules that govern other witnesses, and you may be questioned and examined and cross-examined on any relevant issue in this case. In addition, if you have any convictions involving dishonesty or false statement or for crimes punishable by imprisonment for more than 1 year, and this court determines that the probative value of admitting this evidence outweighs its prejudicial effect to you, the solicitor will be able to introduce your record to attack your credibility. Now, are there any prior?
No, Your Honor.
All right. If you decide to testify, this decision on your part must be freely, voluntarily, and intelligently made with the knowledge of the protections given to you by the Fifth Amendment to the United States Constitution and the consequences of your decision to testify. If you decide not to testify, I will instruct the jurors that they cannot give the fact that you did not testify any consideration whatsoever, and that there is to be absolutely no prejudice to you because you did not testify. It's left entirely up to you whether or not you testify. You may talk with your attorney, your friends and family, or anyone else, but the final decision will be left entirely up to you. Now, do you understand what I've explained to you?
I do.
Do you have any questions about what I've explained to you?
No, sir.
Have you discussed with your attorneys whether or not you should testify in this case?
Yes, sir.
All right. Do you feel like you need to talk to your attorneys any more about this issue?
No, Your Honor.
All right. Is there anybody you feel like you should talk to about this issue before making a decision?
No, sir.
Have you made a decision as to whether or not you wish to testify in this case?
Yes, sir.
And do you wish to testify in this case?
No, Your Honor.
All right. And is this your decision?
Yes, sir.
All right. Anything further the defense wants on the record regarding the defendant's right to testify?
No, sir, Your Honor. We talked to our client thoroughly about her right to testify, as have you, and this is her decision, and we stand by her.
All right. Anything further the state wants on the record regarding the defendant's right to testify?
No, Your Honor.
All right. Will the defense be putting up any other witnesses or any other defense in this case?
No, sir.
No, sir.
All right. So I guess all we have now is closing arguments, charges, and deliberations.
Yes, Your Honor.
All right. Let's take about, I've got some of the charges done. It's probably going to take me about another 30 minutes. I'll finish up charges and get you a copy. You can take a look at it. You can do one of two things. If you want to submit something, you can submit something. If you want to wait and get my proposed charges, review them, and see if you have any objections or additions, then you can do that as well. Okay?
Thank
Your
you.
Honor,
Yes, sir.
quick question. There was discussion about charging the jury before and then closing, or closing and then charging.
Right.
We would prefer you charge before. I didn't know if the state had any preference, or if you had any preference, Your Honor.
Well, I generally charge after unless both sides agree. So
That's fine, Your Honor, and
Whatever the state-
whatever the state would like, that's fine.
We prefer after, Your Honor.
okay, I'll charge after.
That's fine, Your Honor.
So, in the closing argument, since the defense has not put up anything, the state will close in full,
Yes.
then the defense will close in full. And
Yes.
that'll be all of the closing arguments.
Thank you, Your Honor.
All right, let's take about a 30-minute break. We'll come back. Okay, yes, sir.
Let me ask this. We're concerned about one charge you're going to be asked to give, which is hand of one is hand of law. We'd like to be be able to address that before we make our argument.
All right. Well, let's go over that now. Is there a hand of one? I mean, you're saying she committed the act. So what evidence is there that Mr. Dontell committed the act and she was there aiding and assisting in the commission of that?
Well, Your Honor, without being able to read the defense's mind, I'm sure they are going to say that Dontell is the one who killed Mr. Rice.
I'm sure they
Therefore, the presence of both the defendant and Mr. Dontell throughout the night, including going to the preserve, it's up to the jury to decide whether or not they were acting together for hand of one, hand of all, but I certainly think that there's enough evidence in the record with them being together the entire night. Dontell actually driving Ms. Jackson's van to the location, helping to load Mr. Rice's body into the back of the van, again, all the way through disposing of the body. It's up to the jury to decide whether or not Mr. Dontell knew what was going to happen or not. I believe that that's a question of fact to the jury.
But the question is, for this defendant to be guilty under the theory the hand of one is the hand of all, you have to have Mr. Dontell committing the crime and her there aiding and assisting in the commission of the crime. If you have her committing the crime, it's not the hand of one, unless it would be Mr. Dontell guilty under that. A hand of one is the hand of all, is that you are there aiding and assisting someone else in the commission of the crime.
But again, Your Honor, if we're trying to forecast the defense argument, it is likely, I would think, that they argue that Mr. Dontell pulled the trigger. It is therefore up to the jury to decide either way. They can believe all of his testimony, none of his testimony, or part of his testimony. So it would certainly be within the jury's purview to say, well, we believe most of what he said, but we think he pulled the trigger and not her.
Well, what I'm saying is, what evidence has the state presented that he did pull the trigger and she was there aiding and assisting him? That's the hand of one is the hand of all. What has the state presented in its case in chief that shows Mr. Dontell committed this crime and that she is guilty as a principal because she was there aiding and assisting him in the completion of the crime?
I think that given the fact that the jury can believe all, some, or nothing from Mr. Dontell's testimony opens that possibility that he is the one, again, as I'm sure the defense is going to argue, that he is the one who fired the gun and not Ms. Jackson.
What evidence do you have that he is the one that fired the gun?
We don't believe that he is the one, but certainly there is that possibility within his testimony if the jury believes only part of what he said.
Your Honor.
Your Honor, I'd like an opportunity then to do more research if Your Honor
Yeah,
is
let's do
considering
some
that.
research on it, and if there's anything in the record, anything in the evidence that goes to the jury that shows Mr. Dontell is the one that committed the murder and that Ms. Jackson was there aiding, assisting in the completion or commission of that crime, then you've got the hand of one as the hand of all. But as I look back, and I'll look back over my notes, I don't know that I recall the state putting up anything that shows Mr. Dontell is the one who committed the crime. Now, they can argue that, but I don't know that there's anything in the record from the state that shows Mr. Dontell as the trigger person, so to speak. I'll look back over my notes, you do your research, and we'll come back and readdress it.
Thank you.
Thank you, Your Honor.
All right, thanks. Let's take about a 30-minute break.